I now turn to deal with the offences to which each of you has pleaded guilty. For the offence of violent disorder and the offence of possessing an offensive weapon, there are sentencing guidelines which I must and will follow. And principally, my task is to determine in each of your cases separately your individual culpability and the harm each of you caused. Dealing firstly with you, John O'Malley. You're 43 years of age now, and you were present from an early stage at the disturbance on St Luke's Road in Southport. There is very clear footage showing the developing disorder, and you were at the front of what was essentially a baying mob. You were part of a surge that broke through police lines, and you were standing next to the police vehicle that was being destroyed. You were present while missiles of every description were raining down on the officers, including bricks, traffic cones, wheelie bins, road signs, tins of paint, and the occasional firework. It was relentless, and you were at the front and participating enthusiastically. I have seen the footage, and there were plenty of opportunities for anyone to leave who did not want to be there. You were arrested 5 days later and made no comment in interview. You have 2 previous convictions, including a recent one for assault by beating. You have, of course, pleaded guilty, and you are entitled to full credit for that plea. I'm told that you now deeply regret what you did on that night. But apart from that, there is very little further mitigation available to you. Turning to the sentencing guidelines, I am satisfied that your offending falls into culpability category B, because you participated willingly in an incident involving widespread and large-scale acts of violence on both people and property, where there had obviously been planning by someone, and it lasted for several hours. In terms of the harm caused, it is category 1, because almost every category 2 factor is present, and they have to do with the significant resulting injury and fear and distress, serious disruption and impact on the community. The starting point for a category B1 violent disorder is 3 years imprisonment, with a range up to 4 years. In your case, there are significant aggravating features which have not already been taken into account and which justify a substantial upward adjustment in the starting point. You have a previous conviction for an offence of violence. More significantly, you were part of a crowd using obviously racist and religiously intolerant language that was demonstrating quite deliberately outside a mosque. And you were an active and persistent participant, and this combination of factors takes the sentence, in my judgment, to the top of the relevant bracket. Dealing next with you, William Nelson Morgan, you are 6 now, but your advancing years plainly did not prevent you from playing an active part at the disturbance on County Road. You were a part of a crowd of about 100 people who were running amok, setting fire to bins and damaging local property, including a community hub and library which contained a food bank and provided an important resource for the people living in that area, that library and hub based at Spellow Lane. The crowd threw bricks that night and bottles, and bins were set on fire, and they too were hurled at the defending police officers. As those officers were trying to regain control, you were seen at the front of the mob, holding in your hand a wooden kosh, a small truncheon, which you plainly had with you to use as a weapon. When officers tried to arrest you, you resisted with such force that it took 3 of them to detain you. And later, when asked about the kosh, you said, remarkably, that you had taken it with you that night for your own protection. For the same reasons as your co-accused, I am satisfied that this is category B1 offending. There is no suggestion that the incidents in Walton were racially or religiously aggravated, and there may not have been as many people present. But there was looting of commercial premises. There was the wanton attempt to destroy by fire the local library and community hub, and many more fireworks were thrown at the police.
So this is part one of our video on the sentencing of the two men who were jailed between the two of them for more than 5 years for their parts in the Southport and Liverpool riots. As we know, arrests are taking place across the country. More and more arrests are going to take place each day. And I still say I'm looking forward to the Shoe Zone arrest for all of the looting. So far, we have heard about John O'Malley and William Nelson Morgan. John O'Malley had pled guilty to the charge of violent disorder earlier this week, and William Nelson Morgan was admitting to violent disorder and possession of offensive weapons. Now, William is 69, whereas John is 43. So these are quite adult people that are being arrested and charged with these crimes. Stick around for part two, where you will hear the sentencing remarks by the judge. You'll hear what sentences they were given each, and I'll see you there. So let me know your thoughts in the comment section so far on these arrests. Make sure you hit follow so you don't miss the updates on this case, and make sure you are subscribed to my YouTube channel. Then you will be able to join me for lives and my podcasts. Bye guys.